Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Let us start with important updates from the Supreme Court, which opened today after the summer vacations. The bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra heard the batch of petitions challenging the NEET undergraduate 2024 exam. You are aware that various petitions have been filed in the top court regarding the alleged irregularities, paper leak, grant of grace marks, etc. The vacation benches had clubbed these together and were listed before the court today. The court identified 4 red flags in the exam which should be assessed. First, there is unprecedentedly high number of students who secured 720 out of 720 marks. How many of those students are the beneficiaries of the grace marks? Second, students who registered at one center and changed the exam center to take the exam at a far-off place and secured high marks. Third red flag, students who got exceptionally high marks in the NEET but whose performance is not reflected in their 12th exams. However, the bench acknowledged that students may not study that hard for the board exams too. And fourth, students who got exceptionally high marks in one subject but got abysmally low in another subject. The bench first heard the petitions which sought cancellation of the NEET-UG 2024 exam and the results declared on the ground that the exam's sanctity had been vitiated by widespread instances of paper leak, unfair means and impersonation. The court then asked the NTA specific queries on how the question papers were prepared, when they were sent to the printing press, how they were taken to the exam centers, regarding the nature of the paper leak and the steps taken to identify beneficiaries of fraudulent practices. The court has directed the NTA to make a full disclosure before the court, stating that the fact of the paper leak in NEET-UG exam cannot be denied. The court said that it has to be ascertained if the nature of the leak was widespread or isolated in order to decide a retest. The court has asked the Union Government and NTA if they could use data analytics either within their cyber forensic unit or another expert agency to identify suspect cases. If possible, the authorities should determine how to separate the tainted cases from the untainted ones. The hearing in the matter will continue on Thursday. Stay tuned. The Supreme Court today held that there cannot be a bail condition that enables the police to constantly track the movements of the accused and virtually peep into the privacy of the accused. A bench of Justices Abhay S. Oak and Ujjal Bhuya was dealing with a special leave to appeal petition against the Delhi High Court's conditions for granting interim bail to a Nigerian national accused in a drugs case. The court was examining if a bail condition requiring an accused to share their location via Google Maps with the investigating officer violates privacy rights or not. The court said that this bail condition is hit by Article 21 of the Constitution and that there could not be bail condition that defeats the very objective of the bail. Therefore, it has set aside the bail condition requiring the accused to share the Google Maps pin in his mobile device with the investigating officer, and also relaxed another condition that required the foreign accused to obtain an assurance from his embassy that they would not leave India. In the next update, the Supreme Court has today issued notice on CBI's pleas challenging acquittal of Surendra Kohli, one of the accused in Noida serial murder cases of 2005-2006, also known as the Nithari Kand. You must be aware of this gruesome Nithari killings which came to light in December 2006 when the skeletal remains of several children and women were recovered from a drain behind businessman Mohinder Singh Pandey's house in Noida's Nithari. Following an investigation, Pandey and his domestic help Surendra Kohli were booked by the CBI inter alia for murder and rape. The duo was convicted and sentenced to death, Kohli in 12 cases and Pandey in 2 cases. But last year in October, a division bench of the Allahabad High Court acquitted Pandey and Kohli for lack of evidence. Raising questions regarding the manner of investigation, the High Court pulled up CBI for completely overlooking the strong possibility of organ trade being the actual reason behind murders, because the resident of the house adjoining Pandey's had been earlier arrested in the case of a kidney scam. The court said that it appeared that the investigation opted for easy course of implicating a poor servant of the house by demonizing him without taking due care of probing more serious aspects. It was further found shocking that Kohli's confession was recorded after 60 days of police remand without any medical examination. The High Court also noted that no legal aid was provided to Kohli and torture allegations levelled by him were not investigated. Aggrieved by the acquittal, the CBI filed multiple petitions before the Supreme Court, 9 of which were listed today. A bench of Justices B.R. Gavai and K.V. Vishwanathan heard the Solicitor General Tushar Mehta, who argued that Kohli was a serial killer who used to lure young girls and kill them. Calling the killings gruesome, the SG appraised the court that there were accusations of cannibalism and the trial court had awarded death penalty to Kohli. But the same had been reversed by way of the impugned order passed by the Allahabad High Court. After this, the court has now issued notice in the matter. Stay tuned. And now let me tell you that the Supreme Court has today ordered constitution of a separate or joint search selection committee in the ongoing dispute between the West Bengal government and Governor C.V. Anand Bose regarding appointment of vice chancellors of universities. To give you a short background, there is a tussle going on between the state government and the governor's office regarding some VC appointments. Last year, there were 27 vacancies in these positions. The Calcutta High Court ruled that 2018 regulations from UGC should be followed in case of conflicting state university acts. To align with this ruling, the state government passed a new ordinance and proposed a list of candidates for the governor to appoint as interim VCs. But the governor only approved 2 candidates from the list and appointed 13 others without consulting the state government. Further, the government withheld salaries of these 13 appointees, claiming that they were not properly recruited. This led to a retired professor challenging these appointments before the High Court. The High Court upheld their validity. Now, against this order of the High Court, the West Bengal government has approached the Supreme Court in an SLP. In this regard, the top court has earlier urged the Attorney General to resolve the deadlock. It had also stayed the disbursement of financial perks to the interim VCs appointed by the governor as long as the matter was pending before the Supreme Court. Efforts to break the deadlock has now led the court to propose constitution of a search-cum-selection committee for appointing vice chancellors. The committee will be headed by former Chief Justice of India U.U. Lalit as chairperson and will be constituted within 2 weeks. The committee will have 5 members and will create a list of 3 candidates for each university's vice chancellor's position, listed alphabetically without ranking by merit. These recommendations will be sent to the Chief Minister. If the CM finds any candidate unsuitable, they will provide remarks and evidence to the governor or the chancellor within 2 weeks. The CM can also recommend the candidates in order of preference to the chancellor, who will appoint the VCs based on this list. If the Chancellor has concerns about any candidates or the CM's remarks, they can record their opinion with supporting reasons. Once the Chancellor or the Governor approves the appointments, the State's Department must notify the appointments within 1 week. The court has set a 3-month timeline for completing the entire process. The Supreme Court today issued notice in a petition filed by CPIM leader and former MLA M. Swaraj against the Kerala High Court's order that dismissed his petition challenging the election of Congress candidate K. Babu from Tripunithura constituency in the 2021 Kerala Assembly elections. The bench of Justices Suryakant and Ujjal Bhuya passed the order. Swaraj, a candidate for the Tripunithura Assembly constituency, had alleged that Babu distributed election slips with the wording "Your vote for Ayyappan" and the picture of Lord Sabrimala Ayyappa amounting to appeal based on religion, which is a corrupt practice as per section 123 subsection 3 of the Representation of Peoples Act. On being questioned about the issue with the High Court judgment, the counsel for M. Swaraj submitted that the part containing appreciation of evidence contained errors. Though the court was not inclined to issue the notice at first, however, it ultimately acceded and issued notice. Let me tell you that previously the Supreme Court also dismissed the petition filed by K. Babu challenging maintainability of the election petition. The court had observed that the objections raised by Babu against the petition had no merits. To read in detail, please visit livelaw.in. In a significant development, the Supreme Court today dismissed West Bengal government's pleas against the direction for CBI inquiry into the Sandeshkhali violence. The bench of Justices B.R. Gawai and K.V. Vishwanathan was dealing with the petition filed by the state of West Bengal against the Calcutta High Court, directing CBI to investigate the allegations of land grabbing and sexual assault in Sandeshkhali by Shah Jahan Sheikh. The matter earlier came up in April when the court had questioned as to why the state had filed a petition to protect the interest of some private individual. At that time, the counsel for the state had said that there were comments about the state government despite it taking full action. Today, the state's counsel argued that the impugned directions sought to cover not only the incidents of sexual assault and land grabbing, but others as well, such as an alleged ration scam for which 43 FIRs were registered. The bench, however, was not convinced, being of the view that all FIRs pertained to Sandeshkhali and as such, the impugned order was not an omnibus order. The bench dismissed the petition. However, it was clarified that the observations made in the impugned order shall not influence CBI in conducting its investigation impartially. Coming to a short update on the bail pleas of Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia, who is seeking bail in the cases filed by the CBI and ED under the Prevention of Corruption Act and PMLA respectively in relation to the alleged liquor policy scam. On 4th June this year, the Supreme Court had disposed of this bail plea by Sisodia after taking on record assurances given by the Solicitor General that the charge sheet in the case would be filed on or before 3rd July. At that time, the court had also granted Sisodia liberty to revive the bail application after filing of the charge sheet. Sisodia has now filed an application to revive the disposed of petition. His counsel, Senior Advocate Abhishek Manu Singhvi, today mentioned the same before the Chief Justice of India for urgent listing, citing the delay in the trial and Sisodia's 16 months of incarceration. CJI D.Y. Chandrachud told Singhvi that he would look into the matter. In another important case, the Supreme Court has initiated a suo motu writ petition over large sums of money lying deposited in motor accident claims tribunals and labour courts without being given to the beneficiaries. A bench of Justice Abhay S. Oak and Justice Augustine George Massey said that an administrative order has been passed by the CJI initiating a case based on an email sent to the court in May this year. The email highlighted an issue regarding large sums of compensation money lying unclaimed with MAT and labour courts. According to the email, approximately 2,000 crores are lying deposited in Gujarat alone, with no efforts made to trace the beneficiaries of the compensation. Thus, the Supreme Court has issued notice to the state of Gujarat through the Secretary of Department of Law and Justice and the Registrar General of the Gujarat High Court. In the meanwhile, the court has directed the Registrar General of the Gujarat High Court and the Law Secretary of Gujarat to take steps to gather data on the amounts of compensation currently deposited with the MAT and labour courts in the state. The Union government today informed the Supreme Court that a national policy on distribution of menstrual hygiene products to adolescent school-going girls is being formulated and is at an advanced stage. The court granted additional time to Union to collect data and solidify the policy. The bench of CJI D.Y. Chandrachud and Justices J.B. Pardewala and Manoj Mishra was hearing a petition seeking the supply of sanitary products to schoolgirls. Additional Solicitor General Aishwarya Bhati requested the court to grant an additional 8 weeks to consolidate the policy. The bench then agreed to hear the matter in early September. Let me tell you, the petition here not only prays for free sanitary napkins and toilets in school, but also for a 3-stage awareness program. In a notable judgment today, the Supreme Court issued guidelines for visual media to ensure a respectful portrayal of persons with disabilities. The court emphasized that negative stereotypes harm their dignity and perpetuate social discrimination. A bench of Chief Justice of India D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra was hearing a case challenging the certification of the film Aankh Micholi by Sony Pictures, which was accused of depicting persons with disabilities in an undignified manner. Although the court did not interfere with the certification by the Central Board of Film Certification, it used the opportunity to set a framework for portraying persons with disabilities in a way that aligns with the Constitution and the Rights of Persons with Disabilities Act. The guidelines include maintaining language sensitivity and avoiding devaluing terms like cripple, and accurate portrayal of medical conditions to prevent misinformation and stereotypes. To read the guidelines in detail, you can visit livelaw.in. And lastly, the Apex Court today expressed the need for having a uniform model builder-buyer agreement to keep defrauding builders within the check. The bench of CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra was hearing a petition seeking to direct the central government to establish a standardized model builder-buyer agreement and model agent-buyer agreement. The CJI underlined the necessity to prima facie have a uniform model agreement in place across the states in the country. Indicating the pressing urgency of the matter, he remarked that in the absence of any uniform agreement, builders continue to defraud buyers and that the presence of such model agreements will ensure some restraint on indefinite exploitation by the builders. The petition, let me tell you, highlights buyers' ongoing issues, including arbitrary and unfair practices by builders, promoters, and agents. These issues range from excessive delays in property handover to the use of one-sided agreements that disadvantage customers. The petitioner emphasizes that such practices not only violate corporate laws but also fundamental human rights, including the right to life and dignity. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.